Ready to strengthen your reading comprehension? Take a listen.
Let's be real. Facing foreclosure is it's overwhelming. And when you're under that kind of stress, it's so tempting to search for that one magic trick, that silver bullet argument that's going to make it all go away. Well, in this explainer, we're going to separate those popular online myths from the real-world legal strategies that actually can make a difference.
Okay, so here's our game plan. First, we're going to talk about that search for the silver bullet and, why those big theories you see online often just don't hold up in court. Then we'll get into the good stuff, what really works. We're going to build a real legal toolkit, look at a really powerful angle using disability rights, and then at the end, we'll pull it all together into one strategic blueprint. So let's talk about that silver bullet search. I mean, if you've spent any time online looking up foreclosure defense, you've seen them, right? These simple, almost too good to be true arguments that promise to just stop everything cold. And look, it's totally understandable. You're looking for a simple answer to what feels like an impossible problem.
And that really brings us to the million-dollar question, doesn't it? Is there some secret legal argument that can just stop a foreclosure in its tracks? You hear these theories all the time, that the money isn't real, or that there's some hidden defense in the Constitution. They're super popular because, hey, who wouldn't want an easy win? But the only question that matters is, do they actually work when you're standing in front of a judge? Okay, so this is where the rubber meets the road. We're going to put these popular theories head-to-head with what actually happens in a real courtroom. Because, let me tell you, the gap between a great story you read online and a legal argument that actually wins, well, it can be huge. Let's break it down.
All right, first up, a classic. Article I, Section 10 of the Constitution. You'll see this one a lot. The theory goes something like this. Since the Constitution talks about gold and silver, our regular paper money, Federal Reserve notes, aren't real money and can't be used to pay a debt. But here's the reality check from the courts. That section is aimed at states. It's to stop, say, California from printing its own California dollars. It has absolutely nothing to do with whether you or I can use federal currency to pay our bills.
Okay, here's another one you might have come across. 18 U.S.C. Section 8. The argument is that this law proves Federal Reserve notes are just debt instruments, not real money. But the irony here, it's just perfect. This is actually a criminal statute. Its whole job is to define what counts as a U.S. security so the government can go after counterfeiters. So the very law that people use to try and discredit the currency is literally the law that confirms its legal status and protects it. You can't make this stuff up. And to round out our myth-busting, let's quickly touch on the Sixth Amendment. Now, this one is a huge deal in our justice system. It guarantees things like a speedy trial and the right to an attorney. But here's the catch, and it's a big one. The Sixth Amendment is for criminal cases. A foreclosure? That's a civil lawsuit. It's a completely different area of law, so trying to use the Sixth Amendment as a defense just won't work. All right, so if those big, flashy theories are basically dead ends, you're probably asking, well, what does work? Great question. It's time to shift gears. Let's leave the internet myths behind and start building your real legal toolkit with the kind of solid, proven strategies that judges actually listen to. So in the real world of foreclosure defense, it really boils down to 3 core pillars. These are your heavy hitters. Number 1, you challenge their standing, basically their legal right to even be suing you in the first place. Number 2, you find and document every single rule the loan servicer broke. And number 3, you attack the chain of title, which is the paper trail that's supposed to prove they own your loan. Let's zero in on that first one, standing, because honestly, this is where most of these cases are won or lost. Think of it like this. If someone you don't know walks up and demands you pay them for your neighbor's newspaper subscription, your first question would be, who are you? What right do you have to collect this money? That's standing. The bank or trust suing you has to prove, with solid evidence, that they are the one and only legitimate owner of your debt. If they can't, their case can get thrown out. It's that simple and that powerful. So how do you actually do that? How do you challenge their standing? Well, you become a detective and you investigate the chain of title. That's the paper trail. You start by demanding to see the original promissory note, the one with actual wet ink on it, not a copy. Then you put that document under a microscope. You look at every signature, every endorsement. Was it backdated? Was it robo-signed by someone who signs thousands a day? And here's a huge one. If your loan was put into one of those big mortgage-backed trusts, was it transferred after the trust's official closing date? That happens all the time, and it can completely invalidate the transfer. Your job is to find the broken link in that chain. And this quote right here just nails it. The winning path isn't about some grand theory about what money is.
It's about a careful, methodical, evidence-based attack on the nuts and bolts: standing, enforceability, and damages. Do they have the right to sue? Is their paperwork legit? Is the amount they're claiming even correct? That's where you win. Okay, now we're going to shift to a different kind of strategy. It's a little more subtle, but man, it can be incredibly powerful. We're not talking about the loan itself anymore. We're talking about the process. Believe it or not, the Americans with Disabilities Act, the ADA, can become a huge source of leverage if you know how to use it. Now, let's be super clear about something right up front. The ADA is not a get-out-of-jail-free card. It doesn't make your debt disappear, and it won't stop a legitimate foreclosure on its own. What it does do is put rules on how the lender and the court have to deal with you. It's all about making sure the process is fair and accessible for everyone. So what does this look like in practice? Well, you start by formally requesting reasonable accommodations. This could be something as simple as asking for notices in plain, easy-to-understand language, or asking for a bit more time to respond because of a medical condition. The key is you document everything, every request you make, and every time they fail to provide that accommodation. Why? Because you're building a case that the servicer has unclean hands. That's a powerful legal concept that basically says they've acted so unfairly that the court shouldn't grant them what they're asking for. Naturally, a big question here is privacy. Do you have to hand over your entire medical history? Absolutely not. And this is so important. You only need to disclose the functional limitation, the effect, not the specific diagnosis. So you don't say, I have condition X. You say, I have a condition that makes it difficult to process complex legal documents under a tight deadline. You see the difference? It's about the impact on your ability to navigate the process, not the private medical label. Okay, we've busted the myths, we've built our real legal toolkit. Now it's time to put all the pieces together. Let's look at the strategic blueprint for how all this works in a real defense. Think of it like building a house. Your foundation, the solid ground you build everything on, is always your challenge to standing and pointing out servicer violations. That's your strongest stuff. Then you build the frame of the house. This is where those constitutional arguments can come in, not to win the case on their own, but to frame the issue, to argue that the court has a duty to protect the integrity of the contract. And finally, you use your leverage. That's where the documented ADA failures come in, adding pressure and showing the whole process has been fundamentally unfair. So let's just say it one more time to be crystal clear. Those silver bullet theories aren't totally useless, but people misunderstand their role. They aren't the sword that wins the battle. They're more like the lighting that makes your sword. Your core arguments about standing and servicer errors look even more powerful and just. And all of this really boils down to one final crucial question you have to ask yourself. Fighting a foreclosure takes a ton of energy. It's draining. It's about smart strategy, not just raw emotion. It's about putting your limited time and resources into the arguments a judge will actually listen to. So after everything we've gone over today, take a hard look at your strategy and ask yourself, are you fighting the right legal battle?